Everything just shifted. If you carry a firearm, if you train to protect yourself, or if you still believe the Constitution says what it means, what just happened inside the Supreme Court changes everything. A 6-3 ruling didn't just close one case, it redrew the entire map of American gun law. From concealed carry permits and training rules to background checks and constitutional carry rights, every part of the system is being rewritten. This isn't political noise. It's a direct shift in how your rights are recognized and how fast you can exercise them. Welcome to Survival Lawline, where we break down gun laws in a way that's clear, honest, and easy to understand. So before you find yourself caught off guard by new enforcement or state challenges, hit subscribe, stay alert, and we'll walk through each change one rule at a time. Because on this channel, we keep you ahead of the headlines and ahead of the law. Chapter 1. The 6-3 decision that sparked a revolution. When the Supreme Court released its 6-3 decision, it sent shockwaves through every courtroom and state legislature. This case wasn't about politics, it was about principle. Whether a state can make you prove need before exercising a constitutional right. The court's answer was simple. No. That requirement violates the Second Amendment and the historical tradition it's built on. The majority reaffirmed that constitutional carry is the national baseline. Any law demanding proof of need or special cause now stands on weak ground. The court doubled down on the Bruen standard, that modern laws must align with historical precedent. Bureaucratic permission slips cannot limit a fundamental right. This decision didn't just restate Bruen, it expanded it. The court made clear that the Second Amendment is equal to every other constitutional protection. No government agency or local official gets to decide when your rights apply. Chapter 2. May issue permits on the brink. Before Bruen, states like California, New York, and New Jersey could deny concealed carry permits at will. You could pass every background check, pay every fee, complete every training requirement, and still be told no because you lacked a so-called good cause. That era is now collapsing. New York's proper cause rule has been declared unconstitutional. California's sheriff approval systems are under active legal attack. Maryland and Hawaii face injunctions challenging their restrictive frameworks. Federal courts must now demand historical justification, not political preference. States that refuse to adapt risk losing in federal court. The message is clear. Rights cannot depend on an officer's personal opinion. For lawful citizens, carry rights now extend beyond local discretion and across state lines. For years, many states slowed the permitting process until it became its own form of denial. Applicants waited months, sometimes an entire year, while agencies reviewed paperwork. That delay was the punishment. The new Supreme Court standard changes that entirely. The right to carry must be treated as an active right, not a privilege pending approval. Courts are now reviewing permit processing delays as constitutional violations. Lengthy waits can be classified as unlawful burdens on a core right. Illinois and Massachusetts already face lawsuits demanding faster timelines. Federal judges are considering injunctions that would force immediate compliance. You don't wait months to speak, to worship, or to vote. The court just reminded lawmakers that you also don't wait months to defend your life. Every day a state stalls, it risks a direct judicial slapdown. Chapter 4. Mandatory training under scrutiny. Training saves lives, but mandatory government-controlled training can block access to rights. The court drew a sharp line. States may encourage safety, but they cannot impose excessive or historically unsupported mandates. Modern training laws are now being measured against 18th and 19th century practices. Maryland, California, and Connecticut face challenges over multi-day and high-cost requirements. Courts are rejecting pay-to-exercise models, where $400 classes or 6-week schedules create artificial barriers. Historical consistency, not administrative policy, is the new test. This doesn't mean training disappears. It means citizens choose how to prepare, not bureaucrats. Rights cannot depend on wallet size or calendar openings, and that principle is spreading fast. The ruling doesn't remove background checks. It redefines them. The court emphasized that a background system is only lawful if it's fast, fair, and consistent. A pending notice that lasts weeks is no longer acceptable. NICS delays beyond 3 business days now face constitutional scrutiny. State-added waiting periods are being challenged as unnecessary duplication. Gun store holds based on discretionary concerns could be deemed unlawful. Systems like California's 10-day wait and Washington's permit-to-purchase policies are under review. The responsibility has flipped. Citizens are not required to prove innocence. The government must quickly prove ineligibility. A slow system is now considered a broken one. And under this decision, broken systems don't survive. Chapter 6. Training mandates begin to crumble. For decades, states have justified heavy training mandates as safety measures. But after this Supreme Court ruling, many of those requirements may not survive judicial review. When a right becomes too expensive or too complicated to exercise, it stops being a right, and the court notices. Maryland and New York's 16-hour courses are now being reviewed for constitutional excess. California's multi-step qualification process could face a full rollback. States may shift to voluntary or recommended training models to avoid litigation. Courts are signaling that rights cannot depend on arbitrary state-approved programs. The line is clear. The government can recommend training, but it cannot force citizens to earn a constitutional right through bureaucracy or financial barriers. This decision doesn't erase background checks. It redefines their purpose. The question before the court was not whether screening can exist, but how far it can go before it violates historical tradition. Universal background checks without historical grounding may face challenges. Extended waiting periods could be ruled unconstitutional if they lack evidence of necessity. Federal hold policies might require stronger justification rooted in 18th century precedent. New lawsuits are expected to test whether today's systems are preventive or punitive. Founding-era law never required citizens to prove their innocence before owning arms. Under this new standard, modern systems that delay lawful ownership will have to show genuine historical roots or risk being struck down. Chapter 8. Federal vs. State, the power shift. The ruling also reignited a core constitutional debate. When state laws clash with federal rights, who prevails? The court's message was direct. The Constitution does not end at a state border. Federal courts now have broader authority to strike down restrictive state statutes. States that defy the ruling could face rapid injunctions and emergency hearings. Even federal agencies like the ATF are now being measured against the same historical test. Future litigation will likely reach the Supreme Court faster than ever before. The balance of power is shifting away from local experimentation toward constitutional consistency. Every state, regardless of political leaning, now plays by the same historical rules. Chapter 9. The Bruen Standard Reborn. When the Bruen decision was dropped in 2022, it set the foundation. This new case strengthens that framework, transforming it from guidance into binding doctrine. Laws must align with historical precedent or face invalidation. Modern interest balancing, the idea that safety outweighs liberty, no longer applies. Strict scrutiny now governs every Second Amendment review. The Bruen test has become judicial armor against overreach. Every future court battle will hinge on history, not emotion. States can no longer invent new restrictions under the guise of modern need. If it wasn't accepted at the founding, it's likely unconstitutional today. Chapter 10. The Road Ahead. This decision marks more than a legal turning point. It's a nationwide reset. Lawmakers, judges, and citizens are recalculating their next move in real time. Dozens of lawsuits are already invoking this ruling as precedent. Pro-gun states are codifying constitutional carry. Anti-gun states are scrambling to adapt. The ATF's enforcement powers will face renewed scrutiny after recent controversies. Congress and state legislatures are preparing competing bills, some expanding, some restricting. Expect a wave of new cases, rapid appeals, and possibly another major Supreme Court showdown within the next term. The legal landscape is moving faster than ever, and gun owners need to keep up. The Supreme Court has drawn a line, and for once, it's in favor of the Constitution. Rights no longer wait for paperwork, permits, or personal approval. The burden now lies with the government to justify every restriction it tries to keep. For years, gun owners have played defense. Now that's changing. This is Survival Lawline, where we track the real battles that shape your freedoms. Subscribe, stay informed, and never rely on headlines alone. More decisions are coming. More victories are possible. And this community isn't backing down. Stay armed, stay informed, and above all, stay free.